What is the difference between a condo and a co-op? In one of the world's most competitive real estate markets, the difference between buying a condo and a co-op in New York City is far more significant than most buyers realize. When you purchase a condominium, you own your individual unit as real property under New York real property law, receiving a deed with your name on the property records. A cooperative works entirely differently. Instead of receiving a deed, you purchase shares in a corporation that owns the building, and those shares come with a proprietary lease granting you the right to occupy a specific unit. This fundamental ownership distinction cascades into nearly every other aspect of the transaction, including financing, taxes, board approval, subletting rules, and your ability to sell. Because a condo owner holds title to real property, they can mortgage, sell, or transfer the unit, just like any other piece of real estate in the traditional sense. A co-op shareholder, by contrast, holds personal property in the form of stock and occupies their unit under a proprietary lease rather than a deed, meaning different legal rules govern the entire transaction. One of the most significant practical differences Manhattan buyers encounter is the board review process, which is far more demanding for co-op purchases than for condominiums. Condo boards may hold a right of first refusal, but buyers generally face fewer approval barriers because the board's discretionary authority is more limited than in cooperative transactions. Co-op boards in Manhattan typically require a detailed application package, including 2 to 3 years of federal tax returns, bank statements, employment verification, reference letters, and a completed financial statement. After reviewing the package, a co-op board may conduct an in-person interview covering your financial background, intended use of the apartment, and plans regarding subletting. Co-op boards generally hold broad discretion to approve or reject buyers without providing a reason, though they may not act in a discriminatory or bad faith manner that violates applicable law. Beginning July 28, 2026, covered New York City co-ops must acknowledge application materials within 15 days and issue a decision within 45 days after a complete application is received. Financing differences are equally important. Condo buyers often benefit from greater flexibility because lenders can take a traditional mortgage lien directly against the unit as real property. Co-op buyers cannot obtain a traditional mortgage and must instead secure a share loan, where the lender's collateral is the borrower's shares in the cooperative corporation and the proprietary lease. Fewer lenders offer co-op share loans compared to conventional mortgages, and many co-op buildings also carry a blanket underlying mortgage that factors into a lender's evaluation of a buyer's financial profile. A knowledgeable attorney can help buyers navigate offering plans, purchase agreements, board application packages, and closing documentation for both condo and co-op transactions across Manhattan. Whether you're purchasing a cooperative or a condominium, having a lawyer review the building's governing documents and financial disclosures before making an offer can protect you from costly surprises. The law firm representing you at closing can also identify issues with a co-op's reserve fund, underlying mortgage, or board requirements that could affect your financing or long-term ownership rights. Contact Avenue Law Firm, located at 505 Park Avenue #1201, New York, New York 10022, United States, by calling 212-729-4090 to speak with an attorney about your condo or co-op purchase today.